I do have to acknowledge, of course, the Prime Minister, and I'm probably going to embarrass him by saying that I understand that he came here instead of going to drinks for an Australian minister. So I hope I don't get in trouble for being an unpatriotic Australian but dragging away the Prime Minister. And I must acknowledge the Attorney General, not only because he's Attorney General, but because he's from my alma mater. He went to the Adelaide University Law School, and in fact we must have overlapped. He only graduated a couple of years after I did. So I'm naturally inclined to do anything possible to support my co-student from all those years ago. We're both showing our age, I suppose. The Australian National University, yes, it is a national, as the Vice-Chancellor was saying, another national university, and as she was saying, national universities often have a national agenda, and one of the key things in the law of the Australian Parliament establishing the Australian National University was that it was to foster research and understanding of relations between Australia and the Pacific. And in fact, for many years, there was a research school of Pacific studies as a result of that requirement in the founding statute. But now it's a College of Asia and the Pacific, which is unfortunate because it sort of suggests that Asia is more important than the Pacific. But I'm in the Department of Pacific Affairs and I don't agree, of course. So I do bring greetings from your colleagues at the Australian National University who look forward to more engagement with the FNU, and in fact my department has contributed to the funding of getting me here in the belief that it's an important part of building relationships and of contributing to what's happening here. I should apologise in advance for perhaps being a little bit disorganised. This was all put together at very late notice, only last week, and I've been teaching and meeting students and so on, and really only got down to starting to prepare for this properly yesterday on the flight. So forgive me, I've got no PowerPoint. So those of you who love PowerPoints, my apologies. For those of you who get distracted sometimes by all the words on the screen, so you're not really listening, perhaps you'll be okay, you'll manage. I'll do my best to entertain as much as possible and try and keep it interesting. My presentation reflects a lot from practical experience. I've been working as a practicing lawyer since 1976, as the AG said, a little under 50 years. I never intended to be an academic. I don't have an honours degree or a master's degree or a PhD. As far as I know, I'm the only person at the ANU with a professorial position that does not have a PhD. But in the 1980s, when I was first working in Papua New Guinea, I started writing about what I was learning about the use there of the Constitution to try and resolve the conflict about Bougainville's attempt to secede from Papua New Guinea. And I found it fascinating. I'd hated constitutional law at Adelaide University, where it was taught like Holy Writ. You know, the High Court handed down unassailable wisdom that you just had to discuss and analyse legally. You weren't allowed to look at the politics or the economics or whatever. So going to Papua New Guinea and finding that a constitution could actually be used to try and resolve conflict taught me a great deal. And by the way, one of the people I met within a few months of being there was the man who'd helped negotiate the Bougainville peace process in 1975, 1976, one Yash Guy, who's been a friend and colleague ever since. So what I'm going to present is to a large extent a mixture of law and practice, because one of the things I've learned, most constitutional lawyers are focused on the contents of the Constitution, what it says about the problems and about the organisation of the state. But one of the things I've learned from practice is that the process of making constitutions and the processes for amending and reviewing constitutions can be almost as important as the contents. They have a huge influence on the way in which the content is chosen and shaped and changed over time. So it's a mistake, I think, in trying to understand constitutions to focus solely on the content. So I'm going to reflect on years of, or my reflections today will be based on years of work in advising on processes. And unusually, I've been lucky enough to work full-time on constitution-making processes in 2 cases and part-time on a number of others. The 2 that I worked on full-time were both post-conflict constitutions, which taught me a huge amount. One was in Uganda, where I worked, and my family and I lived for over 3 years, from 1991 to 1994. And this was making Uganda's second constitution after the overthrow of its original constitution occurred in the 1960s. And they operated in a sort of constitutional no man's land, sort of constitutional, sort of not. A bit like Fiji has done for various periods, as you know, after coups. So 3.5 years there. It was 2.5 years advising a constitutional commission, and then a year advising on the establishing of a constituent assembly. 2 of my children were born in Uganda. They've got Kampala as their birthplace in their passports, which generates lots of discussion with their friends. They can't remember anything about it, of course. My other child, by the way, was born in Papua New Guinea, because we lived in Papua New Guinea for nearly 20 years. But 2.5 years of that was working on another constitution, which was making the constitution of the autonomous region of Bougainville, established under the Bougainville Peace Agreement of 2001. And I'd been lucky enough to be an advisor to the Bougainville parties in that process, and then took 2.5 years off from the ANU on leave without pay to assist in the making of that constitution. So you can imagine the practical lessons you learn by being deeply involved. Incredibly privileged position for an outsider to be deeply involved in these processes. And that's why I can say I've learned quite a bit about process as well as content. The mixture of constitution making, constitutional design, and the choices of a constitution are particularly important in colonial, post-colonial and conflict prevention and resolution situations. Why? Because the extent to which you involve the broadest possible range of interest groups and the extent to which the ordinary people of the country gain understanding of the process and of the constitution have huge impacts on whether a constitution meets the needs of that country. Where constitutions are made by elite negotiation or imposed by a particular group, it's almost inevitable that the resulting content of the Constitution will be unlikely to really meet the broad range of needs. It just makes sense. One of the advantages of the kind of process which was followed in Fiji in making the 97 Constitution and in making Bougainville's 4th Constitution, the only one that never became a Constitution, that's the 2012 Constitution, both of those had that advantage of being very inclusive, the processes, which I think led to them you mightn't think they're perfect. There might be all sorts of problems with them, but the solutions that they offered to the management of society in Fiji reflected the broad range of views that had been fed in. And I think because the people had been consulted, there was a degree of legitimacy in what was recommended in both of them. So process is really important. I want to start, before I get into the detail of thinking about the 2013 Constitution and the process by which it was made, and whether there are avenues for review and amendment of what appears to be on the face of it a virtually unamendable constitution. But before I do that, I just want to reflect a little bit on what we might have learned through the experience of constitution making processes and constitutional amendment processes in Fiji's history. Because, of course, I would say Fiji's had 5 constitutions: 1970, 1990, 1997, 2012, though it wasn't passed, of course, and 2013. That's quite an impressive weight of documentation. I know of no country in the world, I haven't done a detailed study, but I know of no country that's had 5, or maybe you could say 4.5 or 4.25 constitutions. And why is that Fiji has so many constitutions? It's to a large extent because the processes have not overall been so good, and the choices made in constitutions overall have often, I think, not really met, not in all cases, as I've said, but perhaps have not really met the needs of Fiji. And that's invited what the Supreme Court recently talked about. They commented on the difficulty interpreting the current constitution, where, as they say, we'll come to this a bit later, they point to the wording of quite important provisions of the constitution as being literally unintelligible. It's not proper English. And they've then had to go and try and interpret what was intended. But they point to one of the difficulties being by Fiji's fractured history of coups and other political problems, resulting in constitutions only lasting very short time. So even the court's concerned about that, and the court mentioned not exactly critically, but not very favourably, the lack of public consultation in the process to make the 2013 Constitution. So what have we got in these constitutions? Let's have a quick look at them. I think we've got to remember that Fiji's a post-colonial state where 100 years of the policy of the colonial regime had significant impacts on the country, most notably in the complex population mix, of course, of Itauke, Indo-Fijian and others. And during that colonial period, as the population became more complex and mixed, the colonial regime policy was basically to keep them separate. There were, in many ways, you can understand the reasons why that was at the time. But it then set up a very difficult situation to deal with as you approached independence, because communities that were by then roughly equal in size and have been kept separate had to work out how they're going to work together in the independent state. So the natural thing was to some extent keep what had been in place operating under a new system. And so the Constitution was negotiated basically in London between elite fractions of the Fijian, the Italke and the Indo-Fijian population. And the Constitution, the 1970 Constitution, I'm sure you're aware, was not adopted by the Fijian Parliament, it was adopted by the British Privy Council and was a schedule to an order of the British Privy Council. It came out in the name of the Queen. So what we have here in that first Constitution, as it appears on Pack Lee now, the first few pages are the order in council, and the Constitution comes about 9 pages in as a schedule to what the British had decided. Schedule to the order, the Constitution of Fiji. So choices were made then to basically try and continue the same sort of separation of the two main communities. And the focus was on rights of the communities, as if they were sort of hegemonic entities. They had rights to seats in the parliament, as you know. And there were various other categories of rights, particularly for the Italke. That focus on communal rights rather than any sense of integration and individual rights was written right through the Constitution. That same kind of framework then came under attack, came under threat when the first real shift in power happened in the 1986 elections, and that of course led to a coup. And then in the 1990 Constitution, to a large extent, there was an attempt to keep in place the same sort of dispensation, the same sort of separation of communities and vesting of community rights, but it was not working, and that was eventually clearly recognised by the regime under the present Prime Minister, and earlier than was anticipated under the 1990 Constitution. Of course, you had the constitutional review process set up, which tried to find a new way ahead of a more integrated system, less separation of the communities, and more focus on individual rights. And of course, the parliamentary committee that reviewed the Reeves Commission report watered that down quite a bit, shifted it back to a bit more of the communal focus, but it did make a shift in that direction. So the constitution-making processes then kick in, because you've got a much more open process in 1995-96, leading to the 97 Constitution. It's that, I would say, opening up the process, taking it away from elite negotiation or elite imposition, which you could say was what happened with 1970 and 1990 constitutions. The 1997 Constitution was opened up to a large extent by the process, and that pushed it towards a different framework. That all, of course, then came under attack, not through a military coup, and this is important, I think, but by a coup initiated by others. Yes, there were military involved, but it was not initiated as a military policy, the 2000 coup. And in fact, it was the military that strongly opposed, the military as a body, that strongly opposed it. But that's led to another unfortunate I suppose, first of all, a serious attempt to open up the constitutional choices after the 2006 coup. The Guy Commission was a serious attempt to open up to choices again, but that got shut down because it wasn't acceptable to the then military regime, and again there was an imposition of a constitution without a process that opened up the way to consultation and participation. So we've got those 5 constitutions. The first one lasted 17 years and then was followed by 3 years without a constitution. The next one lasted 7 years, from 1990 to 1997. Then there was only 3 years initially under the 97 Constitution, and that was followed by another year or so without a constitution. So there was a period there under the 97 Constitution when it effectively did not operate, when Bainimarama, etc. were in charge. Then from 2001 until 2006, the Constitution operated. Then I'd say really, although Bainimarama said that he was mounting a coup to protect the 97 Constitution, in fact, of course, the 97 Constitution did not really operate from the end of 96, and so from the end of 2006. So from the end of 2006 until 2013, you operated in Fiji effectively without a constitution. 2013 to the current, 2024, is 9 years. So it's the second longest period of constitutional continuity. But I'd say it's not been a good record this last 9 years, and we'll come back to that. It's worth noting that we've had the 4 constitutions plus 1, various periods operating under the constitutions, none of them for very long. Even the 1970 constitution, 17 years is not particularly long. And you've had 9 or 10 years with no constitution at all. That's a remarkable history. I know of no country in the world that's had so many constitutions, and it reflects a lack of consensus on what the best way ahead is. Let's turn now to the process a little bit more. In terms of constitution making process, it was once very common for them to be made by expert committees, always of males, of course. In independent constitutions for the colonial territories that were becoming independent, there was a heavy influence of the departing colonial powers, and there was an assumption in both the Francophone and the Anglophone countries, even in the Portuguese, there was a natural tendency for negotiation of the existing elites who were seeking to protect their existing interests, and so tended to do so under the existing colonial arrangements. Mostly in these former colonies, the initial constitutional settlement failed eventually because there were various internal problems and contradictions that hadn't been anticipated, largely because the process was not open and inclusive, I'd say. When that happened, it didn't always occur initially that there would be more inclusive processes, but in recent years, since the late 1980s, when countries in the post-colonial world have been replacing their constitutions, they've done so with much more inclusive processes. They vary greatly across the world. In the Francophone countries in Africa, for example, they follow a very French model for constitutional change. They have national conferences, which are quite different from the way we tend to do it in the Anglophone countries, with constitutional commissions and constituent assemblies and so on. In Europe, after the fall of the Soviet Union, there was a different thing with national consultative things, round tables that made the constitution, but generally trying to be as inclusive as possible. And that's led to generally more longer lasting constitutions. So participatory processes have had two main goals. One has been to ensure that there was a broader understanding by the broad population, broader understanding of the Constitution and support for it. And the second goal was to ensure that all voices were heard through consultation. So it was both participation and consultation. And a big part of the reason for doing it this way since the late 80s has been to improve the chances of the constitutional settlement being longer lasting, that it will be accepted by the main groups in the society and supported by the general population. There's been concern about the constant constitutional change and turmoil and threats and conflict. So more inclusive processes are expected to ensure that the content chosen will be more appropriate to the needs of the country and more accepted in the country. What's the experience been in Fiji? Well, of course, as we mentioned on the 1970 Constitution, elite negotiation with constitutional guidance. And it's worth looking to the question of amendment, because one of the ways in which constitutions are made is that they're amended, because that puts new bits into the constitution, removes old bits, changes things. So constitutional amendment processes are really important parts of constitution-making processes. So what did the 1970 Constitution say? There was a 3/4 absolute majority vote requirement for the critically important things, mainly things that protected Italke interests. Not that they were called Italke then, of course, but we do now. But the rest, the majority, 2/3 absolute majority, no requirement for a referendum. 1990, it was a military regime which imposed the Constitution. It was directed still to try and protect Italke interests. The whole communal representation situation still arose. Amendment, section 77, the most fundamental provisions required a 2/3 vote of all the members of both houses, because under that constitution, of course, there was a Senate, and had it included in that 2/3 majority at least 18 of the 24 senators. Other sections, 2/3 majority, and still others, just a simple majority. 1997, as we've seen, a very participatory process, but the outcomes were modified by decision of the Parliament. Again, on amendment, in this case, a vote of both houses, a 2/3 absolute majority, with special provisions applying to the conduct of certain sections. Again, in both 1990 and 97, no requirement for a referendum. The Guy Constitution, 2012, participatory and consultative, as we said. Amendment, there was no repeal of fundamental provisions. citizens could initiate amendment proposals. There was no mention of absolute majority because this was a simple language constitution for the ordinary people to understand. And so instead it says that 48 of 72 would be required, 48 of the 72 members, which is in fact a 2/3 absolute majority vote. But a simple language constitution, you don't talk about things which the ordinary person wouldn't understand. Again, no referendum. 2013 constitution, the military regime imposed it. It promoted, it had the advantage of trying to promote integration, but it was adopted by a process that was non-participatory, non-negotiation. And of course, to amend it, and this is a huge shift from all the previous experience in Fiji, you need a 3/4 absolute majority vote in the parliament, as I'm sure you're aware, and I'm sure it's still not entirely understood because I've had discussions with a number of people about this, Fijians outside and Fijians inside. It's not entirely clearly understood how difficult the second part of the change is. For those of you who do understand it, forgive me if I'm telling you something you know all about. And if I'm wrong, that you all understand it, my apologies. But it's a requirement for a 3/4 absolute majority vote of the registered voters have to vote, not just vote, they have to vote yes to the change that's been approved by the 3/4 absolute majority vote in the parliament. So it's hard to get a 3/4 absolute majority vote. In the past, that's been almost the top level of difficulty for change in Fiji. Now it's been imposed as required for every section, not just some. It was reserved in the past as the top level for the most important provisions, as the constitution makers in those cases thought it was. But now it's 3/4 majority in the parliament for everything, and this 3/4 vote of registered voters voting yes for the change. Now, I'm sure you're all aware the turnout in Fiji with non-compulsory voting doesn't get to 75%. Just the turnout. And of course, that turnout in your parliamentary elections involves voting in different ways. It doesn't involve 72% as that was voting in 2018. 72% voted, but they were voting for lots of different things. The Constitution says you've got to get 75% of all the registered voters, whether they decide to vote or not, it doesn't matter. You have to count on the basis of the registered voters. If you don't get that, you fail. At the moment, in a situation where voting is not compulsory, that's a recipe for an unamendable constitution. So it's a very difficult question when you start thinking about why would it, in a non-negotiated, non-consultative constitution imposed by an unelected body, brought to power by a coup, why would they make their choice of the future unamendable? It's a very difficult question, and I don't think the question's been asked enough, and I don't think we've yet got an answer to it. So what can we say about the constitution-making processes and the amendment processes? I think we can say that the processes in 1970, 1990 and 2013 have been problematic for the reasons already given, partly because they're not inclusive, they're not consultative. The 1997 and 2012 processes were much more positive. 1970, 1990 2013 were all really narrow processes where there was little room for anybody other than those in power to participate. So I think it's clear that there are problems with the 2013 Constitution, and they've been even noted now by the Supreme Court. Now, I'm not saying that there is everything wrong with the 2013 Constitution. It has some positive features. I'd say the pro-integration side of it, the move away from communal voting, is probably a positive step for a country which has a divided ethnic base. But there's a number of quite serious problems with it. I won't go into a lot of detail. Some of this has been written up in reports I was involved in writing for the Citizens Constitutional Forum in 2013, and also in an article I wrote with two colleagues about the 2013 Constitution, published in the Journal of Pacific History earlier this year. Those problems include concentration of power in the executive, an amazing, most unusual in a Westminster-type system, concentration of power, particularly in the Prime Minister and in the Attorney General. Just to give you a little bit of background there, normally the Prime Minister under the Westminster system isn't a presidential figure. There's usually not much mention of the Prime Minister. The focus is on the executive and the cabinet and ministers. The Prime Ministers are sort of first amongst equals. Yet in the Fiji Constitution of 2013, the Prime Minister is mentioned 111 times. And does anybody know how many times the Attorney General is mentioned? 66. The Attorney General in most constitutions doesn't get a mention, not one. Sometimes it's mentioned, but not very much. It's just to say that it usually has to be a lawyer. Sometimes it's mentioned because it's stated that if there is no lawyer elected in the Parliament who can be appointed as Attorney General, you can have it from outside, a lawyer from outside, as has happened, I think, with the current Attorney General. That's then a good reason to have a mention to the Attorney General, because there's something special. Or it'll just say what the role of the Attorney General is as the key legal advisor to the government. Why 66 times? Well, it's because you want to give particular power to the particular person who's drafting the Constitution. So, massive concentration of power. Now, what goes with that concentration of power is something else which is extremely worrying. Accountability institutions. You've got a problem with accountability institutions under the 2013 Constitution. One is that a lot of it has not been implemented. A number of institutions and processes, including standards of behaviour, conduct of judiciary and so on. A number of the institutions and processes have not been established. What were they put into the Constitution for if the regime that instituted that Constitution didn't want them? It looks like it might have been window dressing. There are constitutions, Kenya is one, where there's an implementation commission, because it's quite often constitutions don't get implemented properly or quickly. So in Kenya, the Constitution provided for an implementation committee and for an implementation oversight function in the Parliament, a committee to oversee and report and so on. And it's worked quite well. So it would have been a great step, I think, in the 2013 Constitution to require an implementation committee. But the other serious problem with the accountability institutions is that the appointment processes for just about every major accountability institutional figure is dominated by the government. And the government is dominated by the Prime Minister and the Attorney General. So that's a recipe for ensuring that whoever's appointed is going to be pretty comfortable as far as the regime's concerned, and to ensure that they'll behave themselves, because it's up to the executive government again that dominates the appointment process to determine whether they're removed. So it's a serious weakness in the 2013 Constitution that accountability is not provided for in a proper and independent way. Human rights. Very nice looking human rights bill in the Constitution. Fiji's had wonderful human rights. We could go through all 5 of these. That's one of the reasons why they're so heavy. Has human rights been a good picture in the 54 years of Fiji? Are they well looked after at the moment? Well, in this constitution, they are not really constitutionally guaranteed at all. And why do I say that? Because the Parliament has the right to override any right, just about, if it feels like it. What about the media decree? Was that honouring the guarantee of freedom of information and freedom of expression? Yeah, clearly it was not. And at any time, the government would have been free to undermine, override any others, just about, of the rights in the Constitution. So it's not a Bill of Rights, it's a bill of vague aspirations, or window dressing perhaps. The role of the military. Now I'm afraid I had to ask the Attorney General whether I should talk about the role of the military under the Constitution, and he assured me that I should. Section 131(2) is the only provision about the role of the military. On the face of it, Section 131(2) does not give the military a right to be the guarantor or the guardian of the Constitution. It gives it no such duty at all. The wording does not do that. However, in their submission to the Guy Commission, the military made it clear, I don't know if you're aware, they put in a 110 or 120 page submission rather late in the process. It was made very clear that they saw themselves as the guardians of the Constitution and are there to protect the gains made by the 2006 coup. Militaries around the world are established mainly to deal with outside threat. There's often constitutional provisions which allow them to be given internal roles in exceptional circumstances, basically emergency situations. But when that happens, they've got severe limitations. They can be given powers outside of the normal constitutional role of a military for limited periods and in accordance with the emergency laws made by Parliament. They're held accountable. When the military now in Fiji are talking about a guardianship role, they're suggesting that they have a role beyond Parliament, beyond the government. They're the ones that decide. The strong implication is whether there's a problem and whether they should step in and how far they should step in. Now that's not a good basis for government, and it's not, you would think that if that was intended explicitly in drafting the Constitution, that you would draft it explicitly. It's not stated, it's not there in the words. If you asked an outside lawyer with no knowledge of Fiji to interpret that section, they would not see it as giving the military a guardianship of the Constitution role. Now, this is no attack on the military. I've worked closely with the Fiji military, particularly in Bougainville, in 1994, when they were an important part of the South Pacific Peacekeeping Force, and again from 1998 to 2003, when they were an essential part of the Truce Monitoring Group and the Peace Monitoring Group. I was highly impressed at their professionalism, about how they engaged with the population. They were sensitive, they were committed, they were hardworking. I know their ability in the peacekeeping operations in the Middle East. They're recognised worldwide, so I'm not criticising the Fiji military. I am criticising the notion that a military should be regarded as having a role of unilaterally deciding how it guards the Constitution. Who normally decides whether the Constitution's under threat? It's the government of the day. They're elected to look after the Constitution and to implement it. And when there's problems in understanding what's required or whether there's a threat, they can go to the courts. And the courts are trained in assessing whether there's threats. Even when you have states of emergency situations that the courts recognise after coups, it's the court that decides in the end what the military has done. So let's leave things. If I was advising Fiji, I'd say let's leave things with the courts and the government and let the military continue what they're really trained for, protecting Fiji from outside problems and participating so well as they do in peace building elsewhere. As I say, their contribution in Bougainville has been magnificent. Another really difficult set of provisions in the Constitution are the immunity provisions. Now, probably you wouldn't want to go back and unpick all of that now, but it's to put into the Constitution immunity provisions which are even more unamendable than the rest of the unamendable Constitution. They were so uncertain about what might happen that not only is the Constitution 3/4 and 3/4, but the immunity provisions can't even be amended under those. Yeah, it's not a good look. The electoral system. Now, I said I supported the idea of a more integrative system. Yeah, but the way the electoral system operates, it's been designed, I think, to a large extent to ensure that Fiji First got into power and kept there. The way the PR system works, the single national constituency, no more links of individual members to particular areas or communities, large numbers of members getting in with a few hundred or a couple of thousand votes because they're getting in on the coattails of Bainimarama or Rambuka. It's not a good method of getting the best kind of representatives that are going to really lead the people. So there's lots about the electoral system that's very bad, that doesn't promote good governance. It promotes a concentration of power. It enhances this immense concentration of power in the Prime Minister and the Attorney General's positions. Because all of those members that get in with a few hundred or a couple of thousand votes are totally dependent on number one and number two. Then there's the 103 proclamations and the 328 decrees passed between 2007 and 2014, all protected from any challenge until the Parliament gets round to amending them. Prime Minister, Attorney General, how many of the decrees have been reviewed? Not too many. There's been a few the media decree has been dealt with. There's been a few, but it's a monumental task. The normal thing when a new constitution comes in is you have a provision saying that to the extent that there's an inconsistency in past laws, they can be challenged. If they're breaching human rights, they can be challenged. It doesn't matter how much the rights are being breached, these proclamations and decrees remain in place. There are ways around it. Richard Naidu has suggested that all of the decrees be adopted as statutes, and just listed in the schedule that in the statute that adopts them, and then they would be open to review by a court whenever they're believed to be in breach of the Constitution. I'd say that's a good short-term remedy. But the better remedy, I think, would be to look at the 2013 Constitution and the many inherent problems in it. I'd say that it doesn't even meet, 2013 Constitution doesn't even meet the 2 general principles and the 11 non-negotiable principles that were built into the 2 decrees of the regime that provided for the constitution-making process. And as we'll see in a little while, in my view, those principles, by a bit of an accident when the government was changing the decrees on the constitution-making process after they'd burnt the Guy Commission constitution and formally rejected it, on the 10th of January 2013, the President rejected it, saying it would take Fiji backwards, it would bring economic chaos, and so on. So they formally rejected it. But when they passed a decree in March of 2013, abolishing the Constituent Assembly decree and giving themselves the authority to make their own constitution, they, I think, perhaps just didn't think it through very carefully, and they kept the provision saying that it was the Guy Commission's draft that they were to receive, and they were to then amend that draft if they wished, but that's what they had to work with. They didn't, and we'll come back to that. But if that was true, if that's what they had to do, work with that Guy Commission, the Guy Commission document was required to meet those principles and non-negotiable principles. They included true democracy, respect for and protection and promotion of human rights, removal of systemic corruption, an independent judiciary. How independent has the judiciary been in the last 9 years? Good and transparent government, elimination of discrimination. Now, some of the principles clearly were honoured. The abolition of racially based voting was required. But I'd say a number of them were not met. So even on the basis of the principles advanced by the regime, it's not a good constitution. So where does that leave you? Do you leave it just as it is now and say it's too difficult to change? That's an option. And you might say, well, that's okay because the new regime is a fair and thoughtful regime and will only act fairly. Well, that's maybe true, but every government is subject to temptations when there are pressures. But more seriously, this government got in by the skin of its teeth, despite a pretty bad electoral system designed to keep other people in power. There's no guarantee that a good outcome will come in every future election. And then if a government that had far less good intent came to power, it's got the authority to do all the things that we've just talked about, including overriding human rights, stacking the accountability institutions, etc. So I would suggest it's not really an option to leave it as it is. If it needs change, what's possible? Well, one thing would be to try and use the process in section 160, the 2 steps. The 3/4 parliament, that's a bit more possible now than it was a few weeks ago. The chaos that came out of the parliamentary remuneration problems has left the government unexpectedly with a far greater majority. So perhaps it looks a bit more possible to get the 3/4 majority vote. I don't know. I'm not an expert on Fiji politics. The referendum. Even getting 3/4 to vote would be very unlikely at the moment. However, as I understand it, and I hope I can be corrected by lawyers here, when I look at the 2013 Constitution, there's nothing in there about compulsory or non-compulsory voting. So as far as I know, the non-compulsory voting, which changed from the 97 situation with 2013, as far as I understand it, that's been done in electoral legislation. And I tried to track that down definitely today, but I haven't been able to do so. So my apologies for not being precisely correct. If it is just in ordinary legislation, then I would suggest that one possibility would be to amend the electoral legislation and bring back compulsory voting. It then might just be possible to get a 3/4 majority of those voting to vote for change. You'd have to have a massive awareness program on 2 things: about the change to compulsory voting, so that people do go out and vote, because of course even in the compulsory voting system, some people don't vote. So you'd need that, and you'd need a massive awareness program about the benefits of the changes. Would that be enough? I don't know. You'd have to be the judges of that. If it's not possible to do that, what are the other possibilities? There's been a number that have been discussed. One is to have just a standalone referendum. Call a referendum, have a vote. And that's been suggested by various people at different times. I think that faces problems. People that were unhappy with what you're doing could challenge it on straight constitutional grounds. That's not what the Constitution says. I think you'd be struggling. Another possibility much talked about is just a restoration of the 1997 Constitution. Basically, you'd be using the decisions from Chandrika Prasad in 2001 and in Karase and Bainimarama in 2009, and you'd be relying on the doctrine of necessity. And there's a couple of lines of argument available that could get you somewhere. But there's a fair bit of uncertainty with it, and it could create some rather difficult practical outcomes. You know, if you just argued that 97 is still operating because it was not properly abrogated, and because the Court of Appeal said in 2009 that it was still in operation, that case, of course, has never been overturned, that judgment. But that could see you re-establishing the 2006 Parliament, for example. It could cause a lot of practical difficulties. Another one would be a judicial challenge to the procedure of the non-compliance with Decree number 12 of 2013, which, as I said, abolished the Constituent Assembly, but not the Constitutional Commission that Guy had chaired, or its draft, or the principles and values. They didn't use the draft constitution from Guy. That's clear. It was rejected 2 months earlier by the President in a very formal way. And when you look at the draft, look at the 2013 Constitution, it's not based on the Guy Commission. It's reflecting 1990, 1997. There's a couple of sections out of the Guy document, but it's not based on it. So it's quite possible, I think, that you could argue that non-compliance has been fatal. And under the necessity doctrine, it might be possible then for the court to declare that the current Parliament is legitimately in place, but that it should set up transitional arrangements, possibly reappointing members to the commission that was never abolished, the Guy Commission. Then there's that possibility of arguing that the values and principles in the decrees applied and haven't been complied with. Those decrees had originally had an evaluation process. You might remember when the Constituent Assembly decree was passed at the same time as the one for the Guy Commission, there was provision for a tribunal to be appointed, headed by the Chief Justice and containing members appointed by the Chief Justice, that would evaluate the extent to which the principles laid down in the government's decrees by the government itself, the extent to which they'd been adhered to. And that was, I think, following the precedent of South Africa, which did that with its post-apartheid constitution. And the Constitutional Court there evaluated and said some aspects of the draft constitution were not adequate in meeting the principles laid down, and they had to go back and rework it. That process of evaluation was tossed out when they got rid of the Constituent Assembly decree, and so there's never been a process of evaluating. If we went to the court and said to got the court to see and agree that the principles of good governance, protection of rights and so on haven't been adhered to, the court could go through a similar exercise and exercise its discretion in deciding what should happen. If the challenge succeeded, one of the things the court could do would again be to use the necessity doctrine, and it could declare even particular provisions of the Constitution invalid. So they could say, for example, the Section 160 on amendment, or the Section 170, whatever it is, on the proclamations and decrees. It could say that they in particular don't reflect good governance or don't reflect other of the principles laid down. If the court said that, you could keep the basic framework of the Constitution for the time being and then go and amend to achieve a better outcome. So as I said to the, I think it was on the radio today, or was it to the Prime Minister, there's the English saying, which you would all be familiar with, that there's plenty of ways to skin the cat. In Papua New Guinea, the first Bougainville president used to talk about it in talk business. He'd say, "You got bloody way on Rausim skin belong pussycat." And I'd say, yeah, you got bloody well on Rausim this cat's skin too. There are a number of possible avenues for looking at that 2013 Constitution and perhaps changing it. There's a couple of other issues to think about. If you went to the courts, what would your chances be? Well, very uncertain. Courts are made up of individuals. The politics of courts can be unpredictable. the views of judges vary from very conservative, people who are into literal translation, through to people that look much more at the purpose and try and be liberal in their interpretation and find practical ways ahead. So unless you know a lot about the judges that are going to hear a case, it's hard often to predict. I mean, who would have thought that Justice Gates would have been the hero of Chandrika and the villain of Garase? Judges change their views, as Gates obviously did. So, do we run into a problem if we went to a court, putting aside all of those issues, and go to the court and say, we want you to overrule the Constitution that brought you into office and gives you the authority that you have? It's a difficult situation. But I'd say there are ways around that. The Constitution does give the Supreme Court the power to interpret and apply the Constitution. That's what the court was doing back in June when it decided the case about the disciplinary proceedings that had previously been taken against a person who was being proposed for appointment as a judge and a person who was being proposed as for appointment of public prosecutor. So that jurisdiction is there, so it's possible to go to the court. I think a liberal court wouldn't have much trouble saying that it's a valid exercise of judicial power. There are other arguments that could be advanced. The Indian Supreme Court, since the 1950s, has developed a doctrine of what they call the basic features of the Constitution. The Constitution of India is one of the longest lasting post-colonial constitution, if not the longest lasting. It's been amended a lot, but it's still essentially the same constitution. From the 1950s, the courts developed this doctrine of basic features, which enables it to declare perfectly valid constitutional amendments, amendments that have gone through all the processes in the Parliament and are otherwise constitutionally valid. They are nevertheless declared as unconstitutional constitutional amendments if they breach the basic features of human rights protection, democracy, and so on. So it seems to me that it's possible to develop similar arguments. I'm not aware of this having been done anywhere in the world, and that's why I say it will depend a lot on what judges you get. But it would be possible to develop arguments about constitutions generally, not just amendments to constitutions. There are things like, the standards set by international human rights conventions. Is your constitution meeting those? If it doesn't, is it really valid in a situation like this of challenge? There's also the example from a Quebec case in 1998. You may remember Quebec was trying to be independent of Canada, and there were two main referendums initiated by the provincial government of Quebec on whether they could secede, whether they should secede. The questions asked were pretty vague and woolly. They weren't explicitly yes or no independence, but they were interpreted as that. And in the last of those referendums, it was very close, less than 1% difference, just over 50% voting no and just under 50% voting yes. So the no's lost. So the national government of Canada went to the Supreme Court on a constitutional reference, asking whether it was unconstitutional for Quebec to initiate a referendum and then to decide it was going to secede if there was a vote in favour. Now, obviously, the government expected the Supreme Court to say this was totally unconstitutional. They got a bit of a shock because the court said there are some basic principles which aren't stated in the Constitution but which underlie it. And those basic principles were federalism, democracy, constitutionalism and the rule of law, and respect for minorities. And they assessed what was being proposed by Quebec as not wrong against those tests. They said they don't have a right to secede, but if they had a referendum initiated by themselves on a clear question with a clear majority, then they should have a right to negotiate with the rest of Canada, with the federal government and the other provinces, what would happen next. So there we had a court identifying the underlying principles and making a clear decision on what was constitutional and what was not. It wouldn't be an impossible step for a place like Fiji for a court on the basis of the history, the constitutional history, to work out something similar. I'm not saying it's a recipe, but it's a possibility. There's also the question of acquiescence. Is the 2013 Constitution now bedded down and accepted widely because there's been 3 elections? There is a theory of acquiescence in constitutional law which goes side by side with the doctrine of necessity. It allows courts, if a coup has occurred and there's a new government is bedded down, has strong popular support, there's no clear opposition to it, then the new regime can continue. But that principle of acquiescence doesn't apply if there's been repression and if there's a government that's not democratic. Now, I would argue there has been a history of repression and a history of undemocratic operation. There's been a threat of military intervention hanging over. There's been media suppression. Beyond that, all the opposition parties since 2013 have constantly called for review and amendment. In the lead up to the 2022 election, the current Prime Minister and all the other opposition parties all called for review. The coalition statement called for review. So I'd say it's quite likely that acquiescence would not succeed. So I won't go on any further, I've probably taken too long. In summary, in thinking about whether there should be change, the first question is to decide whether it's to be attempted, because it would be possible for the government just to continue. To a government in power, it must sometimes look almost attractive. The concentration of power, power is attractive. So it wouldn't be surprising if a government didn't want to go ahead, but I'd say it would be a mistake, probably. If it's yes, that you want to try and change, then you've got to first of all decide whether you're going to try and do it under Section 160. You've got to try and work to get the 3/4 absolute majority in the Parliament, and you've got to work to get that 75% vote in a referendum, and that would require compulsory voting and all the awareness that I mentioned. Then there are those other possible ways of challenge, mainly through the courts. If you then do all of that and you do get it overturned, the big question is, what process are you going to use to decide on what goes forward? And we need a consultative and participatory process, history would tell us, if we're to have the best kind of outcome. Thank you very much. I'm very grateful to the FNU for inviting me to come and to participate in this discussion of a really significant issue, not just Fiji, but a lot of other countries. What's happening here is being watched closely by many other countries to see what lessons can be learned. So you're a little bit of a laboratory for constitutional law and process. Thank you very much.